Good morning, everybody. I can see that people are beginning to join us, but there's been a bit of lull in attendance, as I say, people joining in. So I think we'll make a start. Really pleased to be with you this morning, introducing our webinar on employment law. There's been much talk about these employment law changes, and I thought it would be a good idea if we actually had a webinar, which will be recorded and will be on our YouTube channel probably later on today, thanks to Lisa. So yes, so people can try and understand what we all need to be doing. I'm really pleased to have Vinay Tanna with us from Garner Hancock, and also Meena Sangar, who runs her own HR company. So first up, good morning, everybody. So I think, well, without further ado, we'll make a start. So Meena, do you want to start, please? And I think you're going to share screen, and I think you're talking about employment rights, flexible working, sexual harassment protections, and fire and rehire.
I certainly am.
Over to you, please. Thank you.
Thank you. Okay, fantastic. So hi, everybody. Welcome to this session today, a very important session indeed. My name is Meena. I'm a HR consultant with over 15 years of HR experience. I work with startups and SMEs. I'm also an accredited OKR coach and also a performance coach. So there's quite a few employment law changes that have already come in place, and also some coming up very shortly. And we're going to cover today day one employment rights, flexible working reforms, and also enhanced sexual harassment protections, and the new statutory code for dismissals and re-engagement, which is a rehire. And the intention is not just to highlight legal risk, but also equip you with what you need to ensure full compliance and reduce liability and strengthen your policies and processes. In 2026, there are more proposed day one rights that are coming up, and I'll touch on them as we continue through this presentation. So April 2020, employers are legally required to, as you should already know, to provide workers with a written statement of employment particulars. And this document must include essential details such as job description, compensation, the hours that they work, including variable patterns, holiday entitlement, and any training that might be provided. Now, additional day one rights include immediate protection, which is coming up, immediate protection against unfair dismissal. And what's really in play at the moment is unfair dismissal from day one for any whistleblowing and discrimination. And also the right to refuse dangerous work and protection, and an immediate entitlement for the national minimum wage, regardless of length of service. So please ensure your onboarding processes incorporate this, and you must include this in casual and 0-hour worker contracts. So the Employment Relations Flexible Working Act 2023 introduced transformative changes to flexible working. The key changes include employees can now apply for flexible working from day one instead of the 26-week qualifying period. They're allowed to submit 2 applications that are allowable per 12 months. And employers, really importantly, must respond within 2 months and not 3 like it was before. And before rejecting a request, the employer must consult meaningfully and offer alternative arrangements. And rejection must be based on one of the 8 statutory reasonings, like cost, impact, quality, performance. And these reforms reflect a broader shift towards employees' automatic practical rights. And I really must say on this subject that it's really important if you do, as an employer, let's say you get somebody start, they haven't said anything during the interview process, and on day one, they say, well, I can't work 37.5 hours. I can only work 5 hours, let's say, a day. So now, this really does impact performance in a small business. but you really need to take these requests really seriously and have a robust business reason and handle the request effectively and formally, and make sure that you document everything. So the worker protection, which is amended of the Equality Act 2010, was in effect from 26 October 2024. This legislation introduces a proactive duty for employers to prevent sexual harassment in the workplace. So key implications include employers must show preventative action. Although the explicit provision for third-party harassment is not really there very clearly, employers can still face liability and must act where risks are known. And employment tribunals can increase compensation up to 25% of the total reward. So you need to review your anti-harassment policies and deliver regular training. What does that mean practically? That means really reviewing your policies, your processes, related policies like whistleblowing, and also, who does somebody come to if they feel that there's been some sexual harassment? And who do people go to if they notice something about their colleague? So you really need to make sure that you make this process as easy as possible. The key here is taking proactive approach. So proactive approach means give your staff training, let them know in the policies who they go to if there's an issue, but really make sure that it's proactive and you're taking this very seriously, because it can be very damaging for your reputation as an employer. And of course, you don't want to end up in a tribunal or any sort of settlement agreement because there was an issue. So please do make sure you take a proactive approach. So the statutory code of practice on dismissal and re-engagement that changed in July 2024, it doesn't ban fire and rehire practices, but it imposes really clear guidelines and consultation obligations. So when it comes to fire and rehire, employers must engage in early, transparent consultations before proposing, explore reasonable alternatives to avoid dismissal, and if dismissal is pursued, ensure the process is fair and provide information and make sure that it's a genuine re-engagement. And failure to follow the code may lead to a 25% uplift in a tribunal, causes reputational damage, and this code should be incorporated into your policy framework. So what does that mean practically? Sometimes, you're looking to change someone's role from one role to another, and there is material change, and you are thinking of dismissing on the role that they're currently in and rehiring them on, different terms and conditions. It's not as easy as what it was before, so you really need to make sure that you're adhering to the code of practice for rehire, re-engage. So let's summarize the implementation date. So day one employment rights in terms of making sure you have a statement is in force since April 2020. Flexible working reforms, which are effective from the 6th of April. And the fire and rehire code came into effect 18th of July 2024. The sexual harassment protections came into effect 26th of October 2024. And you may have already heard that there's more day one rights coming. So, a lot of employers used to lean on the, after 2 years, people have employment rights. Well, it looks like it was supposed to come in this year. It looks like it's going to be coming in next year, 2026, where you really going to have to think about, what does the probation period look like? If it's 6 months at the moment, maybe you need to change it to 9 months. But you must also remember, with the 2-year ruling, that does not cover any protected characteristics and never has. So please ensure that you really look at your policies, look at your processes, and be ready for the changes that are coming in 2026. So many organizations face reoccurring challenges, and that's really, it's very simple You really just need to make sure that there's, no documentation failure. You're making sure that, if you have meetings with your employees, that you're making sure that you've got detailed notes, you've got detailed onboarding documentation, you've got the right, correct policies and processes in your employee handbooks. Making sure there's inconsistent application of policies across teams. So you really need to make sure that, a precedent is set in terms of how you deal with one employee and another employee. So really make sure that you've got consistent practices. And taking a reactive approach to harassment, that's a really big one. You cannot now be reactive. You've really got to be proactive. So again, look at your policies, look at your processes. And one of the key things is make sure that you are training your line managers and also training your people, your employees, to understand what harassment and bullying looks like, what does sexual harassment look like, and what are the reporting mechanisms, and ensure that you've placed psychological safety into the culture of your organization and a high level of transparency on how you will deal with these matters. And please don't take any shortcuts when it comes to any consultation processes. I come across this time and time again, when you're, going through any redundancies, or, you're thinking of a fire and rehire process, make sure that, that you're not exposing yourself to legal risk and reputational damage. So make sure that your policies and processes are clear, they're part of your onboarding, and make sure that you are consistent in your practices. So next steps, make sure you have an audit and update on all employment contracts, policies and processes. Make sure you train your line managers, particularly around handling flexible working requests. That's a really important one. And make sure that they're handled really well. Develop clear and documented procedures for responding to any sexual harassment. And make sure you schedule, quarterly reviews to ensure you're ahead of any emerging, reviews to employment law. And by keeping ahead and being proactive, you'll be really embedding these practices to make sure you're legally compliant and you don't have any, problems in the long run, but also you are a trusted employer. So that's it from me. Thank you very much.
Thank you very much, Meena. Do you want to stop sharing your screen? And then we'll go over to Vinay. One thing I didn't mention, if anybody in the audience would like to put a question, can you put it in the chat box, please? And then we'll sort those out at the end. So Vinay, over to you. Vinay is actually in Qatar at the moment, where it is around about lunchtime. So over to you, Vinay.
Thank you so much, Sally. Thank you. So good morning or good afternoon if you're here. This is really a broad brush skim through of the legislation changes. So let's go through some of the things. So firstly, let me introduce myself. I'm Vinay Tanna. I'm a partner at Garner Hancock, who have been around for over 140 years. I've not been there as long as that, but over 27 years I've been there, and in law at about 30 years. So I've looked at how employment has changed over the years, and this is really interesting changes. They're quite aggressive changes by the government. And I'm going to just sort of skim through quite a lot, but I'm going to start with settlement agreements because that's one of the questions that was raised. But it's something that all of you really come across all the time, and I just want to broadly give you some changes which will affect you. Firstly, that the settlement agreements are really here to stay. They're going to be, I think they're a good way to bring termination to an end in a very, I think, in an elegant way. And what I mean by that is you have a finality, you draw a line against your employees' rights. Those rights are then limited, and I have a question which I will answer in a minute. How limited are they? A couple of changes, in fact, on settlement agreements, just in relation to compensation. So compensation is going to be beefed up for unfair dismissal, for discrimination, and the statutory limits. So remember how settlement agreements work. They work on the basis of a statutory amount which you need to pay them for every week for every year they work. So that's going up to £719. So £719 for each complete years of service. So imagine that, and someone's been there for 25 years. That's quite considerable. There is a limit up to 20 years. So you cap it off at 20. That's still the same. Some other things which are very pertinent on settlement agreements, the 30,000 wrapper, the thing that really makes settlement agreements attractive, unfortunately remains the same. So the government doesn't want to give you more reasons to tax evade, or tax avoid, I should say. So that 30,000 will remain. We were hoping to have had that increased, because that just hasn't been increased for a very long time. Be mindful of NDAs. A big hoo-ha about NDAs in settlement agreements, where there is something that's gone on in the employment, and then you've effectively created a settlement agreement to gag them. Very important to make sure that that's been used carefully and not to curtail rights, particularly if there's been cases at universities where there's been inappropriate behaviour, and then there's been a settlement agreement which creates a gagging provision. So we, in fact, solicitors have to declare to the Law Society each NDA we enter into. Very interesting that. Just on not on a specific basis, but on a general basis, to how many NDAs are being created. I think that the settlement agreements is the way forward for any termination. Be mindful of a couple of traps. So the question which I was asked earlier on, I think prior, was, can you make a complaint? Can an employee make a complaint after signing a settlement agreement to regulatory bodies? That was a question which was raised. So as you know, settlement agreements completely finish in terms of any rights to bring, except for pension rights, enforcement of the agreement, and pension. They're the three claims which still exist, and of course personal injury claims that you're not aware of. So all of those claims are still existing. But regulatory, very interesting, yes, they leave those open. So the employee has rights to go to regulatory bodies, including the Solicitors Regulation Authority, FCA, etc., and complain. So, it's not completely 100%, but it's near enough. Let's move on. I'm not going to go into the unfair dismissal, Meena dealt with it, but again, these limits have increased. So be very, very careful that the upper limits for unfair dismissal have increased, upper limits for the compensation has increased, and upper limits for vento bans. Vento bans, if you remember, is the discrimination ban. So moderate, middle, and upper ban. So moderate discrimination, middle discrimination, and upper discrimination. So upper discrimination is up to 58,000 plus. So huge amounts of compensation, potentially for people who are on the higher end of discrimination. So be mindful, these have increased, and they're there to stay, and I think they're going to increase further, just as a way of punishing those who have breached that. So I just want to make sure that, just as Meena said, you have good methods or good formulas to try and deal with unfair dismissal and wrongful dismissal and discrimination early on, and have processes in place. 0 hours contract, big thing that's going around about this, because as you know, the government really felt it was a bugbear for them to see people who really aren't promised any hours, and they can be just as and when contracts. I call it as and when contracts. But as you know, as employers, we need those sort of contracts. There's retail, seasonal work, all of those areas, and of course the drivers that bring you Uber Eats and Amazon, and all of those things. Sometimes they're on 0 contracts. So the changes are huge, and they really want to get rid of, really ideally, 0 hours contracts, but they want to create a middle ground. They don't want to create a situation where effectively employers will not therefore employ. They want employment to be there for those type of workers, but they want to have a certain amount of sort of what I call some visibility on hours. So firstly, guaranteeing some hours, compensation for cancelled and curtailed shifts, and these things are supposed to be an appeasement. And what I mean by that is that the employers have said to the government, look, if you get rid of 0 hours contracts, we're just not going to employ anybody. We're just going to employ less people, but on permanent staff, because the administrative headache of trying to deal with guaranteed hours, notice cancellation, then the compensation which goes with it, it's absolutely ridiculous. And it really is not going to be worthwhile for us to have that administrative headache. We're just not going to do it. So we're just going to have a few, rather than have 10 0-hour contract workers, we'll have 2 permanents. I mean, that's literally, I mean, I'm sorry to say that, that's going to create a huge issue for a lot. And remember, 0 hours contracts can actually work for certain people. So what they're trying to do is you actually, in one sense, could opt in. So there's a whole thing. I'd like to see how it really works. And I think that the government will have to think this very carefully. Just like minimum wage, just like a lot of these things which have an impact, even national insurance contributions. You know, I'm doing settlement agreements at the moment at a very well-known estate near where my office is in Isleworth. And, you know, it's an issue for them, you know, huge amounts of pressure for employment, for employers, and they will get rid of people. Right, I want to deal with AI, big thing on the horizon. So I'm going to do myself out of a job now. So let's try and get myself out of being employed, or literally all those grubby lawyers out there. I don't want them to earn from you guys. So how can you use AI? First, I want to try it on the basis of let's work through whether you can use AI to do things which are employment related. So first, I would say get a good employment contract that you use that works for you, and then use AI to really help you to work out changes in that contract. And it does a good job, I have to say. Sorry to say this, but it does do a good job. It's a little bit US centric, but I think it's a useful exercise for most employers to have provisions in there which are tailored for that particular job. So precedents are fine, but use AI, especially some of the premium AI, to try and create provisions within that contract which is really tailored. And that's really useful for you, because what you're doing, you're saving huge amounts of legal costs to go to a lawyer and say, look, I've got an employee which is slightly quirky. Can you make some changes, and it'll cost you £300 or £400, and that could be saved. So it's really, really, really important. The second thing I would really say is use that for procedural matters. So precedent letters, notices, using it for grievances, all sorts of letters are embedded within, particularly the premium versions. Really, really useful, I would say. And I've looked at those myself. We use a different version of that in a sort of legal concept, but they are very good. And I have to say, please do embrace this and use the AI to be able to formulate these letters in a careful way. The next is, I want to go back to the risks of employers. So as you know, banking world, other worlds, just don't like you simply tapping away onto ChatGPT and asking questions during your employment, because what they're really concerned about is what we call seepage. Information which goes into this generative AI, which is, I call it the brain, and it actually sort of remembers things, particularly things like coding, IP sensitive information. You know, if you have the Coca-Cola formula and you put it in, it probably would remember it. So just be mindful of anything that is particularly pertinent, which is particularly protected in employment. Have a GDPR, beefed up GDPR policy, which deals with AI specifically. Make a decision. Are you going to allow them to use it or not? Okay. And if it's not, then you must enforce that. If you are, then you've got to have policies in place. For example, stripped information. So none of the client information should be in there, and you just simply strip it down and ask the questions. That's, relatively, I think it's fine. But be mindful you do have a policy in place. Right, so collective redundancies. So this is something which most employees don't get involved in, because you have to have a really large bout of redundancy, so more than 20 people, and you've got to go into collective redundancy procedures. I call it the tick box exercise, because they really are tick boxes for employers, but they are serious things. So if you get to around the 20 mark, straight away you should be thinking, I've got to go through policy. Even if you're not down the 20 mark, you must have policies in place. I always say, have a policy which is consistent for every redundancy. talk about redeployment, talk about reasonable adjustments, talk about things that you could try and see if you can salvage the job. If you're doing that as a good practice model, you will be very much protected from tribunal actions. Remember redundancies, they're the three classic reasons, remember the ETO, economic, technical, and organizational. Economic, obviously, things go, we don't have enough money. Organizational, reorganization in terms of the employment, the company, and then technical, you're being replaced by a robot. All of those things are important. Consultation periods, you should have a reasonable consultation period, and I would always recommend a month. Now, what the government is doing is going to increase that award if you don't give proper consultation. Then they will give you a compensation up to 2 months' salary, potentially even 90 days. So be careful of consultation, okay? So, if you're just going to call them on Friday and say you can be made redundant on Monday, that is not good consultation, clearly, okay? And they will be entitled to a protective award. Under the current legislation, it's a month's salary, but it could be far more in the new legislation. Oh, I love this. This is little curtains. How nice is that? So I've dealt with all of that. So be mindful of this. This is coming, and it's coming towards you guys. So it is not just for the big employers. It will potentially impact smaller employees. Right, this is the new big one. My gosh, this is the big. I've got to really go into this. So I think this is where you are all going to be affected. It's called the Fair Work Agency. Sounds lovely and benign, but it really isn't. It is, for employers, scary, scary stuff. Because what it does, it's sort of at the moment, it submerges a few of these existing organizations into effectively one vehicle called the Fair Work Agency. And what it does, it's like I think it's the stick of the government, and it's a huge, horrible stick. In the olden days, Sally, do you remember, used to be smacked by a little ruler? Think of the ruler and think of it as a huge stick, which is far more heavier. That's what the Fair Work Agency is. It's horrible, horrible, horrible for the employers, because what you're doing is you're giving this particular body the rights to come in, and this is serious stuff, come into your employment, seize your documents, seize your computers. Seriously, this is how sinister this has become. So why such powers? Because the powers that have been in existence in relation to the other three bodies which have been combined have been lesser so. So, if you've been up to no good, places like car washes, retail, restaurants, all of those places where there is particular what I call not robust policies in place, they are going to be affected by the Fair Work Agency because they have lots and lots of teeth. So firstly, it's a centralized body. It supports both workers' rights, but really it's to do with compliance. Are you doing what you're saying you're doing? Okay, so a couple of big powers. National minimum wage, okay? Now remember, people try and get away with national minimum wage by all sorts of ways, but be careful, you are paying the correct amount. Holiday pay, record keeping, all of those things. Be mindful that you have good HR and good processes in place to work those out. Penalties for underpayment. So employees going to go straight to the FWA, and they will on to you straight away. Powers to issue information notices. So, for example, I want to know this, and this by this date. As I said, enter premises, seize documents, seize computers, and criminal offences for non-compliance. So I've got to say, this is the scary stuff. Sorry to give the scary stuff at the end, but this is really scary stuff, because they're also going to bring in not only, at the moment, so employees have a bit of a gripe. They either leave and then they effectively go to ACAS. That's the first place they go to. Phone up ACAS and say, look, what are my rights? And ACAS will try and broker something. So this is where they would go in relation to the other matters, the Fair Work Agency. So ACAS is still there. The Fair Work Agency is the other place. So if the FWA phone you up, you must take notice, please. Okay. how do you prepare? Make sure you have all your records straight, because ultimately it is documentary savvy. So it will effectively say, tell me how you worked it all out. Tell me why you think it's right, and why does the employee think it's wrong? So all of those things need to be in place. And so there'll be penalties for underpayment and all sorts of things in terms of powers. So just be mindful when you hear about the FWA, be scared, be very scared.
A quick question that's come in the chat box, Vinay, is the FWA in force now?
I'm going to check when it will come in. I will check and come back to you on that.
Thank you.
Thank you. The thing about this also is that this last bit, as it provides legal aid in civil proceedings. I'm not sure that is actually going to be true, because legal aid, there's a constraint on legal aid, no budget for legal aid increase. I don't know how they're going to have legal aid in enforcement. So I'm not sure how that's going to work. So, you know, let's see, I think. Right, trade unions, I'm just going to briefly go through that. Big, obviously, you can appreciate we've got a Labour government, so it's to really recognise the strength of trade union reforms. Number one, lower membership thresholds. Unions can enter and actually recruit. Really interesting, that, I think, and sometimes quite scary, because if you think about it, you have an ununionised workforce, and they could be potentially unionised by a lot of what I call, again, I have to be careful how I say this, but you know, unions who want to recruit and to make sure they've got heavy membership, they can go into a place of work and recruit. Notified rights by employers. You've got to give that notification that you are allowed to and be member of a union, and certain industrial protections now in terms of consultation. So all of those things, be mindful of these trade union stuff, because it's quite interesting. Right, timeline 2026. So as you said, just the increased potential rise in union activity. Right, I'm going to miss this out because it's all to do with schools. And this is also going to be beefed up in terms of school negotiations of teachers and outside bodies and Quangos, etc. So be mindful of that. Right, what's on the horizon? Okay, draft equality bill, beefed up race and disability bill. You should have good policies in place. I always say the way I would tell my clients to be protected is always think of it that once you've been notified of, let's say, for example, the disability in your personal records from the beginning. Let's say someone says, I've got dyslexia. Someone says, I've got this particular disability. You already red flag that. So you're already aware that you need to have particular things in place, you know, whether it's reasonable adjustments, everything. So the personal record is really interesting from the beginning. Once you get notified, that is notification. And effectively, you are put on notice that these rights are potentially available to that person. Race, if there is a grievance, race grievance, then again, it catapults it above the parapet, and you are mindful that this becomes what I call a red flag case. So what you have to be careful about, but the redundancy, all of those things have to be done with kid gloves. The next thing is pregnancy and maternity rights. All of those things create what I call an additional obligation to make sure that you're doing things correctly. So double check, triple check, quadruple check that you're doing things properly. Rights to switch off, really big thing, because everybody's been talking about it, mental health in the workplace, massive issues here. You know, I'm away at the moment, but gosh, how difficult is it to switch off? I mean, I didn't take my mobile for one day, and it was ridiculous. You know, I just can't sometimes switch off. And there has to be a switch off. I'm in favor of this, only because I'm on holiday as well. And I really believe that even people like me should get a break. And I think that this is a quite interesting area. And I just want to briefly touch on this. This is actually, I think employers have to be very careful, because, you know, if you just say, look, please switch off, that is not enough. Okay, it's not enough to say, oh, have a lovely holiday, please don't worry about anything, and then you send a text. Not good, not good. I mean, this is the sort of telltale signs that tribunals are looking for, and the government is onto you. You know, and I'm sorry to say this, but employers forget that the break is supposed to, and I'm going to do it because I'm so in this moment of holiday, that I'll feel probably more invigorated at the end of this holiday. So again, for the employers out there, give them some time off. And by the way, they're on to you. So parental leave, big time, carers, all of those things. There's going to be big things which are going to be on the horizon. I think this is good. I think this is good things. It will create extra pressure for employers, because what you're doing is you're allowing employees to be given that ability to live a decent life. And I think that by giving that, you'll get a better employee. Single status. I just want to quickly talk about this. Okay, as you know, the dirty word at the moment is IR, whatever is 35. There's governments know what you're up to. If you're going to have a self-employed person and you're going to have them for 10 years, clearly they're not a self-employed person. They'll have seeped rights into their self-employment status, and they may be quasi-employment employees anyway. So be mindful that if you're going to have an extended contractor service and contractual relationship, have policies in place. I know that lots of employers will just say 2 years fixed, that's it, you become a permanent or you're out. And so, be mindful of the IR35 trap, and also the fact that ultimately the government is on to you to say, we don't care whether he's a contractor or not, they will have employment rights. So I think that's where it's going. That's it. Gosh, it's all scary stuff, but it's actually fresh, and it's literally, I think the ink's not even dried yet. So there we are. Thank you.
Thank you so much. Sorry, Meena, over to you.
Sorry, I just wanted to add about IR35 and about if somebody's a freelancer or self-employed. A good test is, do they have the right to refuse the work that you've given them? So it's that mutual obligation, really looking at, if you say, okay, I need you to do work on this assignment, and somebody says they got the right to refuse. Yes, I can, or no, I won't. So that's a really good way of judging whether someone, could be misclassified. But a fixed-term employee or a permanent employee cannot refuse work. Otherwise, there will be a disciplinary or something. So just keep that in mind. Would you agree, Vinay?
Yeah, I think absolutely. I think, there's always a rule of thumb here. If they look and smell like an employee, they probably are. Are you inviting them to the Christmas party? Are you, paying for certain things? All of those things are little telltale signs to say really employees. So, you may think you're in a safe position that you've got a contract of services, and you can sack them in 3 months for 3 months notice. There's no unfair dismissal rights. There's no race discrimination rights. There's no disability rights. I'm okay, but you're not. So that's the thing to remember.
And also like to add to, as Vinay was saying, it all feels really scary. I mean, the FWA, it's quite complex. It's going to probably come into effect late next year. But if you take as we've both said, take a proactive approach, audit your own systems, be ready for the FWA, and and think about the new laws that are coming in. And if you're ready, then you can be rest assured that you've taken the steps that you need to.
Brilliant. Thank you so much. There are a few questions. Somebody put a question when they registered. I think this is for you, Meena. Which part of the Employment Rights Bill will come into effect in April 25 in relation to sexual harassment and whistleblowing? I think you covered this in your slides, but could you just elaborate?
It is already in place since October 2024. And yeah, it is very much in place now. So all employers should really make sure they've got robust policies and processes in place, and also make sure that the employment law legislation states that you have to take proactive action. That just putting a policy in place is not going to be enough. Buried in that handbook somewhere, you really got to bring it front and center to show that you're taking a proactive approach. And that includes training line managers and your employees. And that's, what a good employer should do anyway, to make sure you don't have any.
I just want to come in here. It's interesting. I doing this sort of case cases, I always find that if you remember when you were at school, you used to get 10 points for the workings out and 1 point for the answer. That's how employment law works. They look at your workings out. They're looking at the way that you approach this, and they look at documents which record the process. The answer is actually, sorry to put it this way, irrelevant. It is the way that you've approached the question. And that's why there's 10 marks for the workings out. That's how you should look at employment law.
Okay. Gosh, that's simply put. Thank you. Now, I have some rather simple questions because I think the majority of our members are SMEs. So you talked about, Meena, the written statement that so day one, that the new employee has to have the written statement sort of stating the terms. Is there a set limit? So that's not a contract.
That is a contract. So it's a contract, yeah. Statement of particulars, contract of employment, same thing. I mean, it's good practice anyway to, give that before they start on day one. But, I know some employers, I've worked with a few who are retroactively putting them in place later. And it, at the end of the day, the start of, the employer-employee relationship is a good time for employer branding, get everything right from the beginning.
Okay. Brilliant. And with small companies, if there is a problem, it's not so easy to know where to go to because it's a small company. And if there's a problem with the person, probably that person you're going to be sharing an office with. Do you see what I mean? So how does small companies need to have sort of processes in place for where employees can go? How do you tackle that? I mean, is it a responsibility of the board? Is it?
So great question, Sally. First of all, in your policies, it should be very clear who is the go-to person if there's an issue. Now, in SMEs, like you said, if they're very small, this is where it's helpful to have a HR consultant, or because SMEs sometimes do not have their own HR department, or and to an employment lawyer, but you need to have in your policy who is the go-to person. It's not enough just to have a policy and saying we're a transparent employer, and then doesn't give you any details on who to go to in these instances. So they can go to the board. They should be in your grievance policies, in the whistleblowing policies, and in data protection. There should be a named person.
Okay, thank you. You also talked about a probation period for employees. Is there a set limit for a probation period? You talked about extending it to 9 months rather than 6.
At the moment, I think 6 months notice period is good. It gives the employee a chance to see whether the role is right for them, and you to decide whether the employee is right for you. And also there'd be clear KPIs and performance indicators at that 6-month mark. Now, the reason why I said 9 months, and normally I wouldn't say, hey, have someone on probation for 9 months, right, is when the new employment law comes out in 2026, where you've got even more day one rights. So instead of that 2-year, people always look at that 2-year marker. And it had been proposed, and it's been suggested that a 9-month probation period, would be better when that new law comes out. But remember, when when you're thinking about a 2-year, 2 years, that doesn't include protected characteristics, any sort of discrimination or whistleblowing. So, yes, the 2-year mark is there for employment rights for employees, but this is changing as we go along. For example, you've got the day one rights for flexible working. And I keep talking about flexible working. Day one rights is, as an SME, you're a small, tight team. Everybody, contribution counts. So, I always think be ready for if you get a request, handle it very well, and, proactively to make sure that you're really thinking about your business, but also thinking about the employee, but also thinking that you're not going to end up in trouble.
Because I must admit, I thought flexible working was more sort of doing the set hours, but doing it sort of at different times of the day. But so can somebody ask, I love the job, but I want to reduce my hours.
They can ask to reduce their hours because they might have carer responsibilities.
Right.
They may have children, or for other reasons. And flexible working can look different for each employee. So it might be changing their core hours or changing how many hours that they're working. So yeah, has to be considered and has to be consulted properly.
Because I do know that Sanjay, who runs Right at Home, he's on the call today. And he had a meeting with him recently, and he was talking about, obviously, with most of us have got elderly parents or did have elderly parents. We've got, family units becoming smaller. There are more caring responsibilities for people. So flexible working is what a lot of people, need if you're caring for somebody. He was talking much about this. So I'm hoping that we're answering some of his queries. I wanted to come to you, Vinay, because I love your right to switch off. I think you and me both. I always take my laptop on holiday with me. I always do my emails, over a coffee, wherever I'm sitting, for a quick half hour, just to sort of, I don't want to come back to 5,000 emails. That's, I mean, how do you tackle that one?
I mean, I'm only going to deal with it on a legal basis, because obviously
Yes.
on a personal basis, I've already told you what I feel, especially.
And you're on holiday and doing this.
I'm doing this, exactly. I think you've been mindful of any type of communication. So when there is communication between an employer and employee during that time off, it better be bloody good reason why you're doing it. Two is that tribunals absolutely will not like the usual answer. Of course, I told them to go on holiday, have a great time, but actually sinister way of engaging with them during work. There's other ways that they will try and get you to get them to do work. Have this ready by Monday morning when you get back. I mean, clearly, that's an obvious one. So, these are obvious traps for the unwary when you're trying to effectively bypass the legislation, which is probably going to come through. The third thing I would say is that, you have to think of it on the basis of when you're dealing with HR and you're dealing with recruitment, you've got to, if this is the only person who's going to do this, have you got the ability to be able to, if he goes off, she goes off, goes on holiday, how are you going to deal with these things? And I think small businesses have a big issue, because usually it's the one person who's doing it. They know everything. What if something happens that is an emergency? So the way I deal with it is I always tell employers, have a good handover as part of their holiday guidelines. If you're going to take a 2-week break, have in your guidelines, make sure all the handover notes are prepared. Make sure everything that is supposed might happen will be told in the handover notes. So what you've got is an obligation for the person who's going on holiday, to make sure that everything is organised. So, sorry again to put it this way to you, but if then that is breached, and then there's a whole big hole in the fact that they forgot to tell you that the key to the toilet is hidden somewhere else, and nobody can go there for 2 weeks, that is a potential breach. So all I'm saying is, I'm sorry, that sounds very naughty of employment lawyer, employer based, to say, how do you trip employees up? But these are the ways that you have to have protecting yourselves to ensure that there is good handover. That is the way I would advise.
And Sally, I would also like to add, we talk about employment law, but culture in a company, having, it's okay to say we've got a high performing culture, and we've got a culture, but we build a culture built on trust and transparency. And if you get your culture right in terms of how we do things, how we work, how we meet, and all covering what Vinay had just said, if you're upfront about what your culture is, and you're really refining your culture, you're communicating who you are as an employer, and what it's like to work in your particular organization, then that makes things a lot easier for employers. So have a robust culture and make sure that you communicate what that is and build it together.
Yeah, okay, thank you. Because there is somebody in our team I'm trying to persuade to take some more holidays, so I'm working on that one. I'm looking at the chat box. There was a question here: is the the 2-year qualifying period to bring a claim in place. Vinay, is that one for you?
Meena, I don't know. Can you help me with that? I don't know if it's.
I mean, I would say, yeah,
Brilliant.
it's very much the 2 year. What do you mean by qualifying? What if we're saying
Oh,
the 2 years is that's when employees have employment right? It is at this moment in time for certain things, as long as it doesn't impact protected characteristics, based on pregnancy or or anything like that. And also, you've got the protected characteristics, but you've got whistleblowing that that doesn't really apply, or sexual harassment, it doesn't apply. So the 2-year mark is changing to day one next year, and that's what employers need to be ready for. I mean, they should have good practice in place at this moment in time and not rely on 2 years to terminate people's employment. But yeah, it's going to be coming into effect. It was supposed to be this April, but it's now been moved.
okay.
Can I just explain that people think that's a big thing, but it's in one sense, let me just explain how unfair dismissal works, just so you stand back. The unfair dismissal is the compensation for the tribunal to assess as to when that person will get another job. So if that person lands a job within the day one, there is no compensation. If the likelihood of that person with a healthy CV gets a job within 3 months, there's probably going to be no compensation because you would have been given notice in lieu and all the usual things which go with it. It's really extremities, when you can't get a job for a very long time, that's where compensation levels really go up. So actually, at the moment, today, day one rights are discrimination. So you have all the Vento guidelines. So £58,000. Remember that number, £58,000 is the top layer at the middle tier, and then 58 plus. That's what you're in for. All the discrimination claims, whistleblowing, all of those are on straight away. So don't forget, the unfair dismissal is very limited. So just think of it in context. So all the rights, or the big rights, are already in place straight away. Number one. And one other thing I would say: increase in probations. Be very mindful that the tribunals look at this. They say, what are the reasons of you increasing probationary periods? And it could be potentially a grounds for discrimination. So be mindful that if you're increasing probationary periods, make sure you have lots and lots of documents to explain why you're doing that, okay? Because day one rights, as you said, discrimination is day one.
Okay, thank you. Whoa, lots to think about. Meena, you did put something in the chat box about AI. Please make sure you have use of AI policies in place, including data protection.
Yes.
We are holding a webinar on AI, I think on the 13th of May, and we do have a speaker talking about AI and data protection. So make a note for your diaries. But Meena, do you want to elaborate on that one?
Yeah, I mean, recently I've been, creating a lot of policies around AI use, acceptable AI use. What does that mean in that particular organization? What you can do, what you can't do. Some people are on ChatGPT, are not toggling off. There's a toggle that you can put in ChatGPT, let's say, where you can toggle off, share, train the model on your data. You do not want ChatGPT to train on your specific employee data. But also, you've got to think about, if you're on the Microsoft stack, you've got Copilot. How does that, I mean, look, it does make people's jobs easier, but AI also gives you, it hallucinates. So it will give you the wrong information. So, just be very wary of that. Build in your policies, build in your processes on what fair usage looks like.
Okay, thank you. Do you have any other? We've got 5 minutes to go, but we can always finish early. Have you got any other tips? Just one last tip for our audience today. Vinay, I did quite like your business of make sure your working's out. The answer's
Yes.
irrelevant.
I think for employers, I'm really a fan of having the checklists. So checklists are always good. But remember, with checklists, there is a particular, because remember, checklists are potentially disclosable at tribunals, in tribunals' actions. And what you're doing is you're saying, look, I discussed this matter with him or her. I thought about this matter, but tick boxes must also have an explanation. So I thought about this, and the thinking about it is this. So make sure that you don't just tick, but tick and explain. Okay, even if it's standard words, it doesn't matter, because what the tribunal is looking for is to show that there is some thought that has gone behind this particular act or omission. So if you say something, we won't allow you to do this, explain the reasons why you are thinking about that. And remember, it is not the tribunal's job to double guess a business strategy of an SME. Okay, let me explain that. So it is not the tribunal's job to sit in the shoes of an employer and say, oh gosh, that was such a bad business decision. Oh my goodness me, I wouldn't have done that if I were them. That's not their decision. That's not what they do. What they do is they look at what we call the negative decision making. So are there reasons why this decision is actually more problematic than another decision? What I mean by that is, say, for example, there's a history of potential grievances, and then suddenly the redundancy comes about. It looks odd. So what they're looking for, does this decision look incongruous or odd within the scheme of the decision making? Okay, so what the tribunals are looking for is inference. They're inferring from your conduct or from lack of conduct that actually the reasons behind something is far more sinister.
Could I also add, I speak to a lot of employers and they don't understand that a data subject access request. So, but I'm sure you come across this quite a bit as well. Data subject access request is when, if you're writing from the owner of the company to the director of sales about your employee, well, that employee has the right to submit a data subject access request where they are the data subject. So that could include WhatsApp messages, IMs, email. So really make sure that you understand that if you don't want that communication to be shown in a court, in a tribunal, don't write it down on an IM. And that is something I come across quite a bit.
Wow. There's one last question. Actually, somebody's asked for a copy of the slides, so of course we can do that. And then one last question from Sakine. I'm not sure whether sexual harassment has been included in the whistleblowing legislation.
Well, think about the other way around. The sexual harassment in that particular legislation, whistleblowing is part of that. So when you think about a policy is not always standalone. There is, please refer to whistleblowing, please refer to X, Y, and Z. So, there's whistleblowing and then there's sexual harassment, and then it kind of feeds back in.
Brilliant. Well, I think we'll wrap up here. We've got to, it's almost 11 o'clock. I just want to thank you both, Meena and Vinay, and especially you, Vinay, because you're actually on holiday. Thank you so much. I think that was really insightful. As I say, the recording will be on our YouTube channel later on this afternoon. So yeah, please, go visit it at your leisure. Thank you so much indeed, the pair of you. And thank you again. Take care.
Thank you.
Cheers. Bye-bye, everybody.
Bye-bye.